morning from India. Good afternoon to our friends in Southeast Asia. Good evening to our friends in Australia and other parts of the world who are watching this program. We are entering into the third day of this global virtual conference on reimagining and transforming the future of law schools and legal education. We are also entering into the 22nd thematic session of the conference on the theme Role of Regulatory Bodies and Courts During the Pandemic. I'm very delighted to welcome a distinguished set of individuals, legal scholars, leaders, judges who have been part of this panel. Let me quickly introduce them. We have with us Honorable Mr. Justice ARJAN SIKRI, former judge of the Supreme Court of India, currently international judge at the Singapore International Commercial Court. We have Professor Dr. Pip Nicholson, Dean of the Melbourne Law School, University of Melbourne, Australia. We have Professor Dr. Vijay Kumar, Vice Chancellor of the National Law Institute, University, Bhopal in India, and Honorable Mr. Justice Michael Wilson, Judge of the Supreme Court of Hawaii, United States of America. I'm very grateful to my colleague, Professor R. SUDARSHAN, Dean of the Jindal School of Government and Public Policy, who has kindly agreed to moderate this session. When we conceived this conference, one of the things that we were very conscious of is that to what extent the role of regulatory bodies and courts are significantly impacting and shaping the consequences of the pandemic itself. And this juxtaposed with the context of to what extent law schools and legal education should prepare our young people to be part of this process was also equally important. So that led to the creation of this particular thematic session, and we are very excited that we couldn't have found a better group of people representing the legal community, including the judiciary, but also academics who will be engaging in this conversation. I'm going to give this session to Dean SUDARSHAN to moderate it. I'll be back shortly. Thank you very much.
Thank you. Thank you, Raj. It's a real pleasure for me to moderate this session on regulatory bodies, particularly in the context of the pandemic situation. We have a well-balanced panel, I should say, with two academics and scholars and two judges, although it's not quite well-balanced gender-wise. We'll try. And this is a very important context because, you know, the regulatory bodies are important to maintain quality and standards and to have some kind of a uniformity across different institutions that are engaged in legal education and education in general. But the pandemic has posed severe challenges, and we want to explore how regulatory bodies can cope with these challenges, particularly with the introduction of technology. So I know Professor Nicholson's worked on the implications of technology. There are different platforms that we use for teaching. There are concerns about privacy. There are concerns about you know, the multinational or scope of these platforms, whether what's said on them is well protected. You know, for instance, the government of India does not use Zoom because it has concerns about security vis-a-vis the platform we are now using. So if we had somebody from the government, we wouldn't be able to have them on this Zoom platform because the government has decided not to use it. And there have been concerns. So there are all of these concerns as well. And there's a very important concern about students and how to get feedback from them. The regulatory agencies typically don't generally have avenues and modalities to consult with or to take into account concerns of our main constituency, which is students. And so some reflections on that going forward, how we might do that would be wonderful and welcome. So I'd like to, you know, also mention that, you know, the judiciary in India particularly, I don't know about Hawaii, but in India, the judiciary has very often had to intervene in decisions made by the regulatory bodies, particularly the University Grants Commission. and sometimes state governments in terms of what they propose to do with education. And very recently, for instance, the UGC said that in the context of the pandemic, they may dispense with an end of term exam for law students, and the Supreme Court intervened and was concerned that that needn't be done. So in many contexts, whether it has to do with affirmative action, which is a classic instance of the judicial intervention in UGC or decisions of universities. So the judiciary is a big actor, and so it has an important role in keeping regulatory bodies on their toes. And so it's wonderful to have two judges on our panel. But I'd like to begin first with Professor Pip Nicholson on these challenges, particularly how are we to prepare to cope with these technological issues, and in fact, what contribution could the law make and legal education in this context, because it's very important to get that sorted out first, because we've become so dependent on technology, and it's very important that technology is properly regulated, and there are laws and clear rules about it. So why don't you start us off, Professor Nicholson, and then we'll move on about 3, 4, 5 minutes. Thank you.
Sure, lovely, and thanks very much. And welcome to all of those who are participating, and we look forward to your questions. I think the pivot to what I call the virtual classroom in my own case in Australia happened in 2 weeks. In March, we indicated that we would move online, and 2 weeks later we commenced teaching on fully virtually. And there's a separate story which your question doesn't draw on how we engaged with the regulatory authorities here around that pivot, but I'm happy to talk to that later because it was actually a very constructive experience. But we also had to work through very quickly our engagement with technology and the delivery of classes. And ultimately the decision was made to privilege synchronous teaching so that there would be the use of lectures that would be recorded, imagining a flipped classroom modality, because traditionally Melbourne has taught entirely through the seminar mode and a dialogical mode, but we had to revert to a flipped mode. And my staff commenced building lecture content, activities and group work online, but with a commitment to continuing synchronous classroom exchanges. And for that we used Zoom. We used the technology that we're using here today. We have reflected on how this changes the privacy of the student and also the privacy of the lecturer. And one of the considerations is what you do with film if you were to take film, and it is our very strong view at the moment that you ought not. The privacy of the home of both staff and student ought to be protected. But we reflect on collecting and sharing the questions that come through the group chat, the questions that come through group Q&A, because they can be very useful pedagogically for students to reflect on. And also there's a variation of approaches to the audio. But that's one of the first considerations which we had never had to make when we bring staff and students together in a neutral space. Obviously, there's the ongoing protection of IP and teaching materials. There's the ongoing use of security mechanisms through our teaching and learning platform. And in the case of this university, we use Canvas. But I think looking ahead to the question of regulators, for me, there's a separation out around who is the university accountable for the quality of its teaching and who is the university accountable for the substantive quality of its teaching of law. And they're treated slightly differently in this country. But they were some of the preliminary privacy issues that emerged with the pivot to synchronous teaching using a platform such as Zoom.
Well, thank you. I'd like to turn over to Professor Vijay Kumar to, because like many of us, he's dealing with the situation where there's such a diversity in the student population, their backgrounds, where they come from, how many of them can access this mode. There are important challenges and related to equity of access to education. And so we need mechanisms, I think, to keep a tab on how that's going, make changes in order to reach out to certain students who are unable to, say, come on a platform like this. So these are all concerns that I'm sure Professor Vijay Kumar deals with on a day-to-day basis. So could you reflect a bit on those challenges, Professor Vijay Kumar?
Yeah, thank you, Dr. Sudarshan. Good morning, Justice Sikri and Judge Michael Wilson and my colleague Pip Nicholson. It's interesting to discuss these issues openly. I don't think I would like to hide anything. India is a vast country and we have around 1,600 plus legal education institutions. And from 15th March when the lockdown began, the law schools, the law universities, about 24 of them, we have students from all over the country. And some of the law schools also have people from other countries as well. And we are all residential in nature. So evicting them from the hostels and seeing them off was the first task that we had to undertake during this pandemic. We never bothered about the covering of the syllabus for another year, another month and a half for the final examinations in May, June. That I think we never even looked about it. But subsequently, when we started looking at it, let me tell you, it was a huge problem for the law universities in the first place, the regular universities offering law courses, and innumerable private and public law colleges all over the country, which possibly may not have these type of sophisticated instruments, required bandwidth, and therefore the sufferers were the students by and large, because the teaching learning process possibly was not complete. Even in many of the law universities that I represent of, you can see that what we did for 1.5 months for substituting the physical classes was something in the name of online classes. But there was nothing called as online classes. The teachers used to send these PowerPoint presentations to them unexplained, and there was no method of recording and sending the lectures to them. But the summer vacation gave us, and we also realized the seriousness of the pandemic. And therefore, we had to redo the whole lot of things. And we had to, as the law institutions, universities in this country, invest lots of money in technology, in buying laptops for the teachers, because the old systems possibly could not take the load of the present systems. So I think the software process, the bandwidth required, the hardware, and we had to undertake all types of things in the next 2 months. And when we started the next session for this academic year, it was really wonderful. I never thought that we'll be speaking to the students the way that we do in the regular classes. Of course, there is a huge vacuum in the residential universities like ours, where without the students for 8 months, we are also going bonkers. Mm-hmm. So therefore, I can understand the feelings of the youngsters who are not out of their homes for quite some time, and they're all raring to come, but unfortunately they can't do so. But technology, to some extent, Dr. Sudarshan was absolutely right. We have to reach out to students. As I mentioned to you, they are from all over the country. And there are some people from the rural areas, some of them from Jammu and Kashmir, where there is nothing, no connection that is available beyond 2G. And therefore, some of the law schools, like the Nalsar University in Hyderabad, they recorded everything and sent the pen drive by post to those people who could not access the internet-based classes. So therefore, the law schools are able to do it. This is what you call it as the cream of legal education in this country. But looking down, the colleges run by the universities and the private colleges, many of the private colleges have wonderful infrastructure. Possibly they could have done it. But many of the public and private law colleges in this country possibly would have failed. I am very confident that they are not able to do anything meaningful. And therefore, it is a huge exercise. In one sense, I do appreciate the positive side of pandemic, because in every challenge, we have to see an opportunity. And that opportunity is this platform in which virtually we are meeting each other, and we are able to deliver goods to the students. Let me tell you what we did in the first 3 months and what we are doing is absolute U-turn. It's absolute U-turn, and it is really marvelous. And the students are also able to interact. The students are organizing webinars, they're organizing moot court competitions, they're organizing almost every type of competition as if they are physically present on the campus. So these challenges also brings in what you call it as the talent that is required. And this is the time many teachers and maybe senior teachers like us, we also got hooked to the technology, which we never did. So therefore, it brings everyone together to understand the issues properly and effectively. And I think many of the Western universities were really good, really marvelous. They declared that till May 2021, they are not going to have any physical classes. But unfortunately, in this country, with too many regulators around, we were not sure that every month it gets postponed. So the classes will commence in July, August, September. Now up to December, you may open, you may not open, subject to all conditions. I think we have lots of our own, imposed problems on us. But I think it is a marvelous area through which now we are able to interact with many students very meaningfully, including we are addressing the psychosocial problems the students face. We have a counselor appointed on the campus, and she is in touch with almost all the students whenever they have some problems. I think these are all the things which I don't think during regular times we would have done this. But really, this is marvelous. But there are issues. For example, all these lectures are recorded. And if they are recorded, I don't know whether something could be commercially sold afterwards, or whether there are issues of privacy, because I do hear some complaints from parents. Oh, your teachers can't even pronounce the words properly. How can they teach? These are all issues. I think it's a challenge, but I think people will come out of it soon, right? For the next another 3 to 4 months, I don't think any physical classes possibly would take place. I'll stop here. Yeah. I'll get back to Sudarshan a little later.
Thank you very much, Professor Vijay Kumar, and thank you for infusing an optimistic note. Indeed, it's true. For instance, in my School of Public Policy, we've had a board of advisors, international advisors. And what we would do is when they happen to come to Delhi, we would invite them and have a consultation. And it never occurred to us that this is a platform that we could have always used at any time, really, with an international board. So many of us are discovering the possibilities that this platform offers, notwithstanding its downsides. But I think on the whole, it's good to be upbeat about this. And I'm glad that, your students in the Law University in Bhopal, have your leadership and the concern for them. I want to turn to Justice SIKRI to ask, what is, why is the judiciary involved? See, there is the Bar Council regulates legal education. The University Grants Commission regulates all other education. So it's only some professional courses like law, architecture, medicine have come under a different regulatory regime in our country. But the link between legal education, lawyers and judges has always remained very strong. So I'd like Justice SIKRI's reflections on, what ought to be the stance of this regulatory body that's concerned about legal education in this particular context. Is, in your opinion, enough being done? Are there people thinking about what regulations are appropriate? How are we to help legal education institutions in their work?
Thank you, Dr. Sudarshan, and first, good morning to everybody. It's a very important question in our Indian context. Let me first explain in a minute or so the legal regime behind this regulatory process. And then I would come to where the law schools and law universities and legal profession, and then judiciary, that how that relationship comes into being. Now, as you know, there have been various regulators, which we call sectoral regulators now, and particularly after globalization in this country earlier, so many, I'm not talking of education for time being, but general comments, that up to, we know 1990s, etc., it was the government regulation in so many sectors, whether business activities or other activities. But with the opening of the economies, etc., and the many changes were made and statutory regulators were brought in. And these are in every field. You know, it is in insurance, it is in telecom, and all other sectors. Now, you see, the question is that they are regulators, they work within their field, no doubt, and they are experts in their field. This is also, I mean, we have to keep in mind, and we have to keep in mind the role of these regulatory bodies also, which are independent and have been created in most of the countries through statutes, etc. And they are to work, but within the parameters of specified regulatory objectives in each case. Now, in our country, as you know, there is a power of judicial review, which is given to the courts. So therefore, in the exercise of power of judicial review, the courts can ultimately go into the functioning of these regulators as well. So that is available. The question that arises is that to what extent such a power has to be exercised. And that becomes a very, very important question. And if we see the, I mean, the law which has developed in this country, and which is elsewhere also in European countries, UK as well, America and all, and which principles are followed here as well, that normally it is not because they are the experts in their field. And while undertaking the, I mean, exercise of judicial review, the court is not to go into the merits of the decision, but the decision-making process. It is what is to be seen is whether principles of natural justice are followed in a particular case, or whether the, I mean, guidelines which are provided under the statute, they were adhered to, etc. So it is, as it is said, you know, Westbury's principles of, I mean, either fairness is one thing, or which is now incorporated, is that it is on 3 parameters, that illegality, I mean, proportionality, and etc. These are the aspects. Now, having said so, when we come to legal education, as you very rightly mentioned, Dr. Sudarshan, that I would say bonding also and relationship also goes into a different tangent, and different, because it is from law schools that people come into the profession, they become part of the legal system, of which judges are also a part, in a part of judiciary. And it is from this, I mean, legal system only the judges are appointed. So the connection between these three, when it comes to law, it assumes a totally different dimension. And therefore, maybe psychologically or otherwise, as the judges feel that, look, they have a larger role and more important role to play. Of course, when we come to sectoral regulation, insofar as legal education is concerned, we have UGC, which is in a way generally regulating the education of all types. And specifically, when it comes to legal education, we have also Bar Council of India, which is a statutory body. Now, so therefore, what happens is, and as you know, because the issues involved are of the students or of lawyers or budding lawyers, and they have all connection with the legal profession also. So they would try to, in comparison with other sectoral regulators, or as is rightly said, other branches of law, other branches of education, here the tendency is also to approach the court on the drop of the hat. But when the matter comes to the court, court has to decide. And in a case like this, the question that arises is, what kind of control should be there, or what kind of exercise of judicial power which should be there while dealing with this. Now, as far as policy matters are concerned, it has been accepted, as I said earlier, that that is the forte of these regulatory bodies, and courts are not going to substitute their judgment into that. But again, when it comes to legal, maybe wittingly, unwittingly, knowingly, unknowingly, because the judges also know about legal education. Because when it comes to, if it's a matter regarding, say, engineering or medical, the judges may not have knowledge. But when it comes to, I've seen, like, for example, when even the exams and some exam in a university or exam of even judicial, appointments, etc., when it comes to the court can look into the questions, whether the answers are right and not, although they will not do this exercise when it comes to medical, because they don't know anything. So they will say, no, those people, they know better and they will do their job. But when it comes to this, they will go into the merits also of the exercise, as I said, maybe unwittingly. But then, having said so, what happens in the context of, if you know, here also the Supreme Court had interfered recently in a matter, but then that became important in that case because of the dispute between the two regulators, or regulator on the one side and the government on the other side. Like if you remember, the question was whether the student should be upgraded to the next classes without any exams. UGC stood the ground and said, no, sorry, under the regulations, there cannot be, the exams will have to be there, maybe little late because of pandemic, etc. Now, many state governments and many state universities said, no, we want to cancel these. So therefore, it is the dispute landed before the court, not because of any other reason, because of the difference of opinion between these two, and naturally, and students also did not want that, no, we don't want to take exams because of this pandemic and the threat of exposure to this COVID-19, physical exams, etc., should not take place. So all those issues did arise, and which had to be settled by the court. So once such issues would arise, it is ultimately the court who has to settle. Of course, as I would say, it is not necessary to state in detail what happened in that case, but to some extent, some kind of balancing approach was adopted by the court. But what I would say at the end, when these such issues comes, that of course the wisdom of the regulatory bodies have to be kept in mind and have to be respected. At the same time, it has to be a collaborative decision making for the betterment of the students. That should be an approach of the judiciary. Thank you.
Thank you very much, Justice Sikri. For the benefit of those who may not know, Justice Sikri is known as the Professor Judge, and he was teaching in Delhi University and was one of the most sought after and popular teachers. But again, the regulator comes into play. He had to stop after 5 years because the Delhi University ordinance wouldn't permit a part-time teacher beyond 5 years. Now, one doesn't understand the rationale for a regulation of that kind. But somehow regulators seem to be able to hit upon regulations or rules. It's difficult to fathom why or what's the rationale for it. So with the result, of course, subsequent classes of law students in Delhi University, missed out. And so this, but he's well known as the Professor Judge. And I now want to turn to Justice Michael Wilson, because you see, one of the things, Justice Sikri explained why it is that there is a natural tendency for members of the bar and the judiciary to take an interest in what's going on in legal education. However, that legal education has itself changed. It's become very interdisciplinary. I mean, you would like legal education to have a very strong emphasis on understanding climate change, environmental issues, and you can't call yourself a qualified lawyer unless you're sensitized to that kind of a subject. So I would therefore ask you, what are your reflections about what a regulatory body for legal education ought to do in our current context? Both, you see, as we are in an age where the planet is threatened and there is this pandemic. In all of against all this background, do you think there's need for some radical reform in the way regulatory bodies approach legal education?
I appreciate that question, and you know me well, Dean Sudarshan, Brother Sudarshan. Let me say aloha to Professor Vijay Kumar, as well as Professor Nicholson, and my friend who I look up to tremendously, Justice SIKRI, who I do think of as a professor as well, because what I'm going to say, you can tell, is in a way a real request for maybe some feedback, perhaps at a later time, from all of you, because you are architects of education and a contemporary moment in time, when the contemporary moment is a strange one. So with that in mind, let me talk about the strangeness that we perceive on our court here in Hawaii. Understand that we have one law school. Oh my goodness, you can imagine what the relationship is between our court and the law schools. We're ready to take over. Let the professors get out of the way. We can explain what the curriculum should be. We can talk about what kind of computers they should have. So it's, from a professor's point of view, a bit of a challenge. But also, we are the most remote landmass on Earth, and that causes us to be somewhat introspective. So what is happening, though, is a almost mirror of what's going on with India and perhaps as well with Australia. In other words, we have law students who are now looking at future education in a way that no law students have before, and in the midst of a society that's changing so rapidly. And that means that the challenges that we're facing at the moment have to be seen in a broader context involving the future. Justice Chandrachud spoke about that in his valedictory address. So our court, our Supreme Court, has to look towards the future. What are the trends for the future for justice? My goodness, if you were a billionaire, you know, the Bloomberg Index keeps track of billionaires. So that since the beginning of the year, this has been a great year, a really good year. 23% return on investment if you're a billionaire. Almost unprecedented wealth creation. One of the more controversial billionaires that we have in the United States, you've probably heard of, and that is Elon Musk. And just in the last year, and much of this has been the last few months, his wealth has increased $100 billion. So there's a trend of great wealth and great influence. And I know, because I've learned from my brothers in India, how much that other part of the population that Justice Chandrachud spoke about is doing, because it's sort of the reverse in Hawaii. We have the highest unemployment. We used to have the, approximately a year ago, we had the highest employment. Now we have the highest unemployment. And we don't have a lot of emergency room space. So the trend with respect to justice is such that this tendency that's happening in the United States, where there's a lack of access to justice for those who can't afford it, is accelerating. And the influence of those who are in positions of authority and wealth is increasing. What does that mean with respect to regulating from the point of view of a court? We had to decide what was going to happen with the BARSA that was being given to our students here as well. Well, Justice Chandrachud said the financial crisis of the pandemic cannot justify overwhelming economic oppression. We have a lot of law students that can't really afford to go through this process again of taking the bar. So we had to postpone the bar because of the amount of COVID. Then do they have to take the bar? And if they take the bar, as Dean Sudarshan has alluded to, should they be close together? So to wrap up my point about where we were a divided court. There were those of us who felt they don't need to take the bar. This is a good law school. And look at what's happening to the part of the population that is focused on justice. You know, it's of course an open secret, perhaps, but it's nonetheless an open point to all of us. Lawyers are the handmaidens of the powerful. And the powerful are more powerful. And the wealth available to court the best law students is even greater. So yes, maybe there should be some serious reform when the court intervenes and says in the curriculum it's going to happen, it's important to pay attention to the underprivileged, the disadvantaged, that part of the population that defines justice, because that is harder to reach now. And the students that care, the students that will define who becomes judges, because as Justice SIKRI said, I mean, I have advocated actually this rather eccentric process of selecting judges in India, where the judges select the judges. The court selects the judges. But what you end up with, at least, is a way of identifying people that are committed to justice. And so I'm an advocate now of don't require a bar here in Hawaii, because that will allow those that can't afford to take the bar to take it, because they can't take it more than once. And even more to the point, those that don't do so well on the bar often are from a disadvantaged background, but they're committed to principles that are more important than ever before. It's more important than ever before for society to have individuals that will attend to what is an increasing potential, if not reality, of injustice in terms of human rights, and also a potential increase, and I think a very dramatic increase, in the violation of rights of future generations, because of the fact that the regulatory agencies as well as the courts have not been responding to this existential threat of climate change. And if they're isolated in individual rooms and they're not allowed to mix with society and they're not allowed to represent that part of society Justice Chandrachud emphasized, it's in a pluralistic society, it's a society that needs to have recognition before the courts, and it needs attorneys that will take those very important emerging social issues before the court. So I'm really concerned about the virtual nature of the education as well as the restrictive nature of the education, and that it does not seem to assist disadvantaged societies nor the attorneys that have justice in mind when they go to law school. So
Thank you.
Thank you.
Thank you very much. That's important reflections. I want to turn back to, there are a number of questions now that people have posted. I'm afraid I can't take all of them, but I wanted you, Professor Nicholson, to complete the thought that you hinted at, which is the dialogue you had as the Dean of the Law School and the University with the regulatory body in Australia. Very quickly, if you can, tell us about the outcome.
Absolute pleasure, Dr. SUDARSHAN. It's a very interesting story. The Victorian Law Admissions Board is our regulator, administering a national uniform scheme that only 2 states have signed up to at the current time, New South Wales and Victoria, and Western Australia to join in relatively soon. So we call that regulator VLAB. VLAB reached out to us in the middle of March and said, we recognise that you will be transforming legal education. We want you to consider what you need to do and then articulate for us how you will meet the requirements that are set out under the Legal Profession Uniform Law Application Act, meet our admission requirements, accreditation requirements. And so we set up a committee of 3 who worked across every subject, looking at what the substantive learning requirements were and what the attributes, methodological attributes of the student needed to be, and how we would deliver that, and then documented that back into our regulatory body a month later. That was a very large piece of work. concurrently with that, we were, as I described before, flipping our teaching and moving online. And I do note the very prescient comments about the difficulties that posed for students who are less resourced than other students, and the commitment the university and the school had to do to make sure that students had both laptops and access to IT infrastructure. But the challenge is arguably slightly less than I can fully appreciate it was for the schools and students of India. So that the equity considerations were live. But having documented our changes to the regulator, they accepted those. And we didn't propose to cease assessment. We proposed to continue teaching and to deliver assessment, albeit in very different circumstances. Some of the law schools across the country suspended for a week or two and ran a week later in order to do the reconfiguration of the teaching. In our own case, there was a decision across the university to delay for 1 week and run the semester 1 week longer. The law school itself resisted that, but nevertheless, that's what took place. At the end of the day, I think what really helped in our relationship with the regulator here, and where Australia is somewhere between the Hawaii example and the Indian example, 39 law schools across the country, say 6 in my state. And there has always been, at least in the recent past, a very transparent process around accreditation. And that transparency and the clarity of the requirements and the clarity of a process to demonstrate that you've met those requirements meant that it produced what I've, on reflection, preparing for this, thought of as agility and trust between regulator and schools, at least in this state. And so, you know, we document on the papers how we meet those continuing requirements, and they trust us to deliver those undertakings that we give through that process. I've got to say, not every state in Australia reached out to schools in the way they did in Victoria, and I really commend our regulators for that. And I know we've got short time, a very quick extra comment. Our regulatory body is led by a retired judge, includes a judge of the Supreme Court, and then the profession is represented, the bar is represented. And that breeds structurally a consultative forum at inception. And there is a tendency lest we simply don't have the litigation that Judge SIKRI pointed out is endemic, and the sort of hyper involvement of both students, governments and regulators in testing the legislation. It's not present in Australia in that way, and certainly there's no litigation in Victoria at all. Although there's a mechanism for judicial review, it hasn't been tested. So I think a lot of it was trust, transparency and agility were the things that really assisted us at a very critical moment. And my heart goes out to all of you working in a system where there is a litigious streak. It must really complicate things for the deans of law schools of India.
Thank you. Thank you very much, Professor Nicholson. Very important observations, which leads me to ask Professor Vijay Kumar. You know, the National Law School of India, the first director was Professor Madhav Menon, who we sadly lost. But he was in charge of legal education in the Bar Council. So he moved, as it were, I mean, he had to be persuaded to take up the directorship of a very innovative and new adventure with the National Law School in Bangalore and the 5-year program. So Professor Vijay Kumar knows that well. So I'm going to ask him that if he were in Professor Menon's place in the legal education part of the Bar Council, you know, what thoughts would you share with them in this context?
Right. Thank you. That's a very tricky question, Dr. Sudarshan. I appreciate and I envy Professor Nicholson for the proactive regulator that they have in Australia. And as Justice SIKRI mentioned, that we have too many regulators in our country. So therefore, to very quickly suggest something, It's very difficult. I have been on the Legal Education Committee of the Bar Council that drafted the first set of rules way back in 2008. So we brought in some shape to legal education through that. And I was also part of the second regulation that is being now sent to various law schools for vetting, right? The revision or acceptance, comments, whatever it is. It is yet to come into force, but I think the second policy is also already on the web. And many law schools are supposed to respond to that. Now, this is one issue which whether the Bar Council should govern everything is something that we need to look at it. I would also just flag in something because the question is on what I would do in the place of Dr. Menon. Justice Sikri is also present here. I would like to take invite his attention as well. The new National Education Policy 2020, which has been rolled down by the Government of India very recently, is bringing lots and lots of what do you call it as spirit and life into higher educational system in this country. And therefore, but very carefully, they have excluded legal education and medical education out of its purview. So it is time for the judges, the lawyers, and the academia to sit together to frame a regulation, a set of regulation, where I think not one single body should be given the authority to determine, and it should not come from above as a dictation. It should be through the process of consultation with all these three. Justice Sikri was absolutely marvelous and right. The law students first, the lawyers second, and the judges who are all, it's a link, it's a continuum. And all the three must play a major role in deciding a single regulator for this country, which we don't have a law. Of course, Justice Sikri will also appreciate that the Bar Council has been given the responsibility only in 1971, not before that, because Bar Council is created under the Advocates Act, which comes only after the courses are over. So they cannot be our regulator. So these are all issues, but still we have accepted. But time has come under the new education policy, and with all the diversities that we have, very quickly to capture one or two issues of the policy, that the autonomous universities, single faculty universities like the law universities, 24 of us, will also transform into multidisciplinary university by 2035. So as Vice Chancellor, as leaders of these educational institutions, we have a lot more responsibility of integrating the other disciplines also, which we have done. In many of the law schools, you see interdisciplinary courses are being taught the best. So therefore, we are not hesitant in doing that, but the phase that it is a law school, a law university, that tag will vanish in the next 15 years. So therefore, the regulator, which should represent all these three bodies, the students also should be taken on board because they are the affected interest. And through the process of consultation, we should have one single independent regulator to emerge. In the next 1 year, once the pandemic goes out, I think there will be a wider consultation with all these three stakeholders coming together, and that is going to create a different type of development in this country as far as legal education is concerned. I'll stop here. If there are any questions, I'll be too happy to respond.
Thank you very much, Professor Vijay Kumar, and thank you for bringing up the new education policy and its expectation that all universities would be multidisciplinary. Justice Wilson would be very happy about it because with emphasis on environmental concerns. Now the questions that we've got quite a few, but interestingly, they are questions that are directed mostly to the courts and the judges, which is first one question is about, or one set of questions are about courts conducting their proceedings online. I mean, the legal education is one thing, and the risk of some iniquities in that, because we've had currently many, and they are reflected in many comments that viewers have had. How do judges prioritize cases? Because in this online mode, the usual ways of determining which cases are taken up may change. And there are concerns about equity there. They think that, you know, and the role of the Chief Justice as the master of the rolls, determining which cases will be heard by whom, kind of thing. So there are a set of questions about that. So, you know, in deference to those questions, I'd like Justice Sikri to give us a few reflections about that.
Actually, it's as you know, Professor Sudarshan and Professor Vijay Kumar also from India, and everybody, that this is a very hot topic, much talked about in recent times because of various reasons, and I need not go into that. At the same time, yes, COVID-19 situation, which has, I mean, one thing which was triggered because of that was that the hearings started taking place only in a virtual mode, initially particularly. And so therefore, it was only through video. And as physical courts had to be closed because of this pandemic, like all other institutions, including law colleges. But at the same time, as very rightly pointed out, those who want to put these questions and want to ask this question, is that this justice delivery is also one of the services, if I may say so, which is an essential service, because so many issues which would keep arising, like in this case, and which have arisen even because of pandemic. Like we gave the example of this, whether the exam should be held or not because of pandemic, and the issue landed up in the court. So, and the issues of personal liberties, etc., bails, which had been the subject matter of discussion in our country, and so much of debates on that, those issues would be there, and therefore the access to justice has to be there, and speedy justice has to be there at the same time. So therefore, on the one hand, the courts are not able to function in its full strength in physical form, and the courts are having few matters. Of course, over a period of time, with the partial lifting of the lockdown, some physical hearings started, and even our, as it happened in education, it happened in on the legal system also, that over a period of time, the virtual mode of conducting the hearing also improved. And today I've seen many in Supreme Court or many high courts, particularly I know Delhi High Court and some other high courts also, who are almost working, if not to full capacity, at least 70 or 80% of the normal capacity, they are working like that. But then in the whole process, when the cases cannot be taken up in a regular manner or in a routine manner, then the question arises, as you put, that how to give the preference to those cases which need immediate attention, and the cases which can be delayed or which can be taken up later. In India, COVID or no COVID situation, we have this kind of problem always because of the arrears in this court. Today, there are in our courts, from Supreme Court down to district courts, of course, the figure is much more in district court, but the total cases, I think Michael knows it, whether Nicholson knows it or not, there are 30 million cases pending in India. So if that is the backlog, and in each court, the dockets are overflowing, which case should be given primacy or which case should be given preference has always been an issue. It's not that it is now. Yes, it is reflected now. But question that arises is that, of course, like if I take the example, which may be in the mind of the person who has asked this question, that Arnab Goswami and bail granted to him within 24 hours, Supreme Court did that. So why it should not be extended to others? So therefore, what I feel is, as a master of roster, Chief Justice, either Chief Justice of India in the Supreme Court or Chief Justices of various high courts, etc., they should come out with a clear policy on this. It has become very, very important, because the court should not be, the subject matter of ridicule on this, and the courts strive on the trust of the people. That is very, very important. As it was said by American jurists long ago, that the judiciary has neither the purse nor the sword. and it is only the trust of the people which makes us going. So therefore, in order to assuage the apprehensions and feelings of the people at large, that there should be some policy, some norms should be laid down by the courts, that how matters should be taken up, so that there is a transparency. Today, the problem is little opaqueness in this. That is creating the problem. Maybe not that the courts are internally what is happening is wrong, but it is not known to the people. So therefore, once there is a transparency, there are proper norms, proper guidelines, how the cases would be listed, which kinds of cases they may relate to personal liberties of the persons, they may relate to social justice, like or the issues, emergent issues arising out of pandemic only, like say, take the example of migrant laborers, which we face those problems, then where the justice is required to be done to millions of migrant laborers immediately. So such cases should be taken up. So, but then there should be a clear-cut policy, I would say, in order to avoid such debates in public, and the court should come out, more cleanly on this.
Well, thank you very much, Justice Sikri. That's very important advice. I'm sure that judges will pay great heed to what you just said, the need for clarity and transparency in how difficult choices are to be made. I'd like to have Justice Wilson say the last word. We are coming to the end of our session. Thank you. Justice Wilson attributed, referred a lot to Justice Chandrachud's talk in our conference, and the need for looking at justice from the vantage of the voiceless and the weak, and also to have an adequate reflection or representation of society on the bench, the diversity aspect. But with respect to this set of concerns about prioritizing cases, any reflections on that? Because most of the questions we've got have to do with this. There's a great anxiety and concern about how is it that issues are prioritized. The docket may be large, but you still have to deal with some matters on an urgent basis. And if that is so, what criterion of urgency would you apply, Justice Wilson?
Well, I think that this asks a question that is telling one, as you have pointed out, Justice Sikri, in terms of how society perceives judges. How far do we go in distancing those that dispense justice from those who seek justice? Some of it's straightforward, although unfortunately, as straightforward as it is, it doesn't seem to be getting a reaction from courts that might be commensurate with the Constitution. All of us deal with constitutions. And when you think of the core rock solid principles of justice, it has to do with taking people's freedom away oftentimes. So without question, I think it's necessary to provide priority to those who are facing the possibility of freedom being taken away. And in our court, for example, there's great controversy about the concept of taking away the right to a jury trial for an indeterminate period of time. It's greatly, I think, undermined the degree to which the courts are seen as doing their job. Because we have big buildings, we have spaces, it's possible to have a jury. Similarly, if you are accused of an offense, it is also an iconic principle that it's important to see the person. Of course, it's also important to see the judge. So I would submit that in the criminal context, it is important, and we should never lose the significance of in-person proceedings where the judges can be seen as well as the accusers, and the fact finder, whether it's a jury or a judge, is watched as they go through the process. And this creates a certain amount of transparency. There's desperation and there's fear growing. There's no doubt about it around the world. And the courts are the possible reservoirs of a sense of solace and a sense of justice, but not unless there is some notion that there is going to be a new renewed commitment to allowing for a kind of judicial process that is personal and not getting more and more distant. So yes, we prioritize constitutional rights that deal with the freedom of individuals as a significant way of prioritizing our cases.
Thank you. Thank you very much. I'll now invite Vice Chancellor Rajkumar to join me in thanking all of you. It's an enormously educative and interesting panel. Thank you all very much for sparing your time. Over to you, Raj.
Thank you very much, Dean Sudarshan, for so skillfully moderating this panel. Thank you to Justice Sikri, Justice Wilson, Dean Nicholson, and of course, Vice Chancellor Vijay Kumar. So many important issues that we discussed in this particular panel has resonated across the conference, but also beyond. I am really grateful to each one of you for taking the time out to reflect, but also to answer and respond to some of the questions posed by the audience. This session is over.